In conclusion, your lordships, your ladyship, in an old story, and it's probably even true, when the authors of the American Constitution declared after months of work in Philadelphia that they finally reached consensus, a lady by the name Mrs. Powell shouted a question to the revered Benjamin Franklin, an American statesman, who was then 81 years old. And this is what Mrs. Powell told Benjamin Franklin. Dr. Franklin, what have you given to us? A monarchy or a republic? And this is what your lordship, your ladyship, Dr. Franklin answered the lady. A republic, if you can keep it. The judiciary must stand as the unyielding guardian of the Constitution the pillars of justice and democracy begin to crumble. I submit. Thank you.
Thank you. You, Bananjeru.
Yes, my lady, my lords.
How are you?
I'm well, my lords.
You have 10 minutes.
My lord, I'll try to do the best within the time allocated.
All right.
My lord, my lady, my lords, permit me to join issues with the earlier submissions made by my learned friends. And permit me, my ladies, my lords, to submit that my submissions will majorly...
Issues on the same side. Join issues. We haven't submitted.
What problem do you have with that, Professor Gender?
My lord, join issues means he's on the opposing side, but he's supporting the applications as framed. So I don't know whether it is simply a question of not knowing that we haven't spoken, perhaps. He's running low on sugar.
My lord, the presiding judge, you made an important point that we are Africans.
I think let Njiru proceed.
And he will have his time to speak the right English when his time comes. My ladies, my lords, my submissions will deal with the aspects of public interest in respect to the reason why the court must sustain the conservatory orders as granted by his Justice Mongo and Justice Mwita. Your Lordship, permit me to begin by drawing your attention to the dictates of Article 3, which requires every person to uphold and protect the Constitution from being violated. My lady, my lords, the Constitution that we are here to protect this afternoon is a document that is progressive in nature and that seeks to protect individuals who either serves in government or out government in whatsoever organ. My lords, in my address, I'll majorly deal with the question of the purported nomination of Professor Kithure Kindiki and whether the lifting of the conservatory orders will culminate into his swearing in and what that means in respect to the provisions of the Constitution. My ladies, my lord, it is clear that a purported process took place in Parliament that culminated into a name being forwarded to Parliament for voting. My ladies, my lords, it is important for us to interrogate the circumstances that led to the forwarding of this name, and whether or not that process is confirmed with the dictates of the Constitution. My ladies, my lords, on the 18th of October, we worked towards what friend Mr. Ongoya submitted on a memorandum by the President. The said memorandum, my ladies, my lords, that the President from the independent commission. And the answer was sufficient enough to afford him the courage to forward the name for voting in Parliament. The question begs an answer is, did the IBC possess the requisite constitutional capacity to submit or approve the said name for purposes of voting in Parliament? My ladies, my lords, the answer to that will be found in Article 88, as read together with Article 99 and Article 137 of the Constitution. Article 88, my ladies, my lords, creates the Electoral and Boundary Commission. And in the same article, my ladies, my lords, creates the functions of the said commission. You'll also find the same answer, my ladies, my lords, in the amended IBC Act. Most importantly, Section 10 and Section 11, which I'll be dealing with in the near future. My ladies, my lords, Article 99, as read together with Article 137, provides the qualifications for an individual to hold the office of the president, and by extension, the office of the deputy president. It is important to note, my ladies, my lords, that in the event anything happens and the current president is incapable of the office of the president, the purported name, if sworn in, will be the person to take over. Necessary requisite qualifications, and that these qualifications are met. My ladies, my lords, that the constitutional organ judicial notice, my ladies, my lord, that the commission as currently constituted falls lack of the commissioners. And the question, therefore, my ladies, my lords, in the event to evaluate the qualifications under Article 99 and Article 139, can be submitted in Parliament for voting. Who then is capable of doing that in the absence of the commissioners? My ladies, my lords, we submit that IBC as currently constituted can only execute administrative functions, and it has no capacity or ability to execute the function under Article 99 as read together with Article 137 of the Constitution. My ladies, my lords, the Constitution as read together with the IBC Act has created distinct functions that for the commissioners and the secretariat. And you'll find that, my ladies, my lords, in the decision, consolidated petition number 305, which was between Engineer Mwaura Kamau, Charity Kalukingilu versus EACC. A three-page judge, my ladies, my lords, had that to consider whether the secretariat, in the absence of the commissioners, can take the functions designated and exclusively allocated to the commissioners. My ladies, my lords, at paragraph 347, this is what the court had to say. From the foregoing provisions, it is clear to us beyond that the membership of the Constitutional Commission is between 3 and 9 members. In other words, the composition of the Constitutional Commission ought not to be less than 3 and not more than 9. The court goes on to say that if the secretariat, and in this case, the CEO to the IBC, would then be seen to execute the functions of the commission, it would then mean that the commissions would go beyond the constitutional dictated number of either 3 or 9. The court said at paragraph 348, the said members, otherwise known as the commissioners, are empowered to appoint the commission's chief executive, known as the secretary. To contend that the secretary, who is an appointee of the commission, is part of the commission would mean that the commission would, where commissioners are 9, be composed of membership of 10. The court said one only needs to mention how ridiculous this argument is. It is therefore our submissions, my ladies and lords, that the name that was submitted to Parliament is not capable of replacing, in the event this court dismisses our petition and upholds the impeachment, the Deputy President of the Republic of Kenya. The court further said at paragraph 353, I refer the court to have a look at paragraph 353 and paragraph 354. But of the most importance is what the court said relied in the case of petition number 46 of 201. The court relied in a Ugandan case, and this is what the court said. It is clear to us that under the Constitution and under the legislations, the foundation of the power of a secretariat is the existence of the commission. The secretary and the secretariat can only carry out the powers vested in their offices when the commission is in place, exercising its powers since they implement what the commission has approved or resolved. Again, I urge the court to look at paragraph 356 and also 358. But most importantly, your Lord, my ladies, my lord, is what the court is saying at paragraph 362. This is what the court had to say. We therefore also agree with the petitioners that any decisions purportedly transmitted to the DPP recommending the prosecution of the petitioners without the sanction of the commission would not be in compliance with the law and the Constitution. We urge you, my ladies, my lords, to find that the name that was submitted in Parliament is not capable of replacing the Deputy President of the Republic of Kenya. Why is that important, my ladies, my lords? Because if the orders are lifted today, that will be the next course of action.
My lord, that's not a finding you can make in your ruling on an interlocutory application.
Well, why, my ladies, my lords? Because this is a train with many compartments and many stopovers. The next stopover that we shall land on, my ladies, my lords, if the orders are lifted, is to have a person who was not duly appointed in accordance with the Constitution taking over the office of the Deputy President. My ladies, my lords, permit me to draw your attention to paragraph 365, 336, and 337 of the same judgment. And this will be my final submissions in respect to this judgment. At paragraph 367, the court is saying, whereas a commission may be disabled in its ability to perform its functions, such disability does not automatically render the commission extinct. Such an event, in our view, only places the commission in a state of dormancy as it is able to carry out its functions. My ladies, my lords, I have perused the replying affidavit filed by Marjan on behalf of the IBC. He makes no reference to the memorandum filed by the President. My ladies, my lords, he technically makes sure that he does not make reference to that so that he may not be seen as if he has devolved into the functions of another organ. My ladies, my lords, permit me to draw your attentions to section 6 of the appointment, I beg your pardon. Paragraph 6 of public appointment parliamentary approvals. And as you look at paragraph 6, also look at the definitions contained at paragraph 2 of the same act. What an appointment means and what a candidate means. And for avoidance of doubt, a candidate means a person who has been proposed or nominated for appointment to a public office. Section 6 creates the criteria upon which Parliament must follow so as to satisfy the need for public participation. It also creates the time in which to be executed. It has been submitted that this was supersonic speed that took approximately 6 hours, and the Republic of Kenya had a new deputy president proposed. But the question might be, can this be done in the absence of the exercise of the sovereignty of the people of Kenya? If we were to allow this, my ladies, my lords, what will be the import and what will be left of Article 1 of the Constitution? Will it be to mean that Article 1
Say bye-bye to FOMO, the fear of missing out, by downloading the KBC online app that gives you access to everything you love. Get the latest news, sports, music, entertainment news, live TV, live radio, and so much more at the palm of your hands. To get the app, simply search KBC Mobile Digital App in your Google Play or App Store and download the app. Catch what you want, anytime, anywhere. Stay connected. Stay ahead with KBC Mobile Digital App.
Greetings in the name of the Most High Jah Rastafari. My good name is Marley Moses, the positive warrior, alongside.
Yes, sir, DJ D-Rage, the baddest, each and every Wednesday from